Roman culture began not with philosophy, but with order. Mommsen opens his discussion of Roman law by emphasizing that the Roman instinct was never speculative. It did not seek truth in theory or metaphysics. It sought stability through regulation. While Greek minds reached for ideals, the Romans built frameworks. They did not ask what justice ought to be. They asked what could be enforced. From the earliest days of the city, Roman life was structured through clearly defined relations between master and client, father and son, debtor and creditor. These were not loose conventions, but structured expectations repeated across generations. Law was not an abstract good. It was a tool for organizing power, regulating conduct, and resolving disputes in a way that preserved the collective. Mommsen makes it clear, the Roman citizen was trained to think in rules. Where others might appeal to custom or conscience, the Roman reached for precedent. And those precedents were layered into daily life, governing how contracts were made, how inheritances were distributed, how wrongs were righted. The law was not separate from religion. In fact, it was born out of it. Early legal acts were ritual acts, performed with precise gestures and sacred phrases. To swear an oath, to enter a contract, to manumit a slave. Each required the correct form, because the form itself had power. A legal error was not just procedural, it was sacrilege. This early Roman legalism was not flexible. It was rigid, even unforgiving. But that was the point. In a world where violence could erupt at any breach of trust, certainty was the highest virtue. The law existed to prevent discretion, not to allow it. And yet, within this rigidity, Mommsen finds genius. The Romans developed a legal culture that treated the world not as a place to be interpreted, but as a system to be managed. Every relationship could be described. Every right could be claimed. Every wrong could be corrected, if not morally, then procedurally. Law, for the Romans, was not just a civic necessity. It was a national instinct. They built with it. They ruled with it. And eventually, they would export it across the known world. Before laws were written, they were spoken in ritual. Roman law, in its earliest form, was not a matter of debate or documentation. It was custom sanctified by religion. Mommsen stresses that in archaic Rome, legal authority came not from civic deliberation, but from divine precedent. The first Roman laws, the leges regii, were attributed to the kings, but their legitimacy rested not on royal will, rather on their invocation of the sacred. Each legal act was a performance, a contract, a trial, a declaration of property. None could proceed without the exact words, the precise gesture, the right sequence of steps. These formulas were guarded closely because they held power. Mispronounce a word, and the act was void. Perform a gesture incorrectly, and the gods might withhold their sanction. This made law inaccessible. Knowledge of these formulas, this ius, was confined to the patricians and, more precisely, to the pontifical college, Rome's priestly elite. They were the custodians of legal tradition, not just in doctrine, but in form. The law was not just controlled by the upper class. It was literally encoded in language that only they knew. Mommsen describes this system as both closed and conservative. It was not designed to evolve, but to repeat. What was just had already been revealed in sacred precedent. Innovation was heresy. The priesthood did not interpret law, they recited it. Yet this structure gave Rome something extraordinary, a unified civic religious framework in which obedience to law was obedience to divine order. Legal disputes were not secular arguments. They were matters of cosmic alignment. Justice was not a matter of fairness. It was a matter of proper invocation. The rigidity of this system would, in time, provoke resistance. The plebeians would demand access to the sacred words. They would force the codification of the 12 tables. But even then, the Roman attachment to form remained intact. Mommsen's insight is sharp. The Roman state began not as a political abstraction, but as a cultic discipline. Law, for early Rome, was ritual with consequences, repetition as control. The law protected Rome's order, but that order served a class. Mommsen does not flinch from the reality that early Roman law was an instrument of patrician dominance. It regulated society, yes, but it also preserved hierarchy. In form, it brought stability. In practice, it maintained exclusion. At the heart of this system was control over legal knowledge. The patrician class, through the priesthood and its monopoly on the ius, retained sole authority over the procedures and language of justice. They alone knew the sacred formulas. They alone could interpret omens, dictate calendar dates, and authorize legal action. Without their participation, a plebeian's claim could not even be heard. Justice was not blind. It was veiled, and the patricians held the veil. Mommsen underscores how law and religion were fused to the benefit of the elite. The calendar itself, deciding which days were auspicious for legal proceedings, was kept secret for generations. Legal failure often resulted not from a weak case, but from missteps in the ritual performance of justice. Say the wrong word. Appear on the wrong day. Forget a symbolic gesture. The case collapses, and the plebeian is left exposed. The law did not need to be unjust in content. It was unjust in access. Even civil protections, such as the right to appeal or transfer property, were bound by layers of formality that the lower classes could not penetrate. Procedure was not a neutral structure. It was a barrier, precisely maintained. And so, legal conflict became class conflict. The plebeians demanded transparency, not simply representation, but access to the process itself. The legal struggle was not over outcomes, but over visibility. Until the 12 Tables, the law was unwritten, and what is unwritten can always be denied. Mommsen's reading is clear. Early Roman law was not simply an evolving civic code. It was a mechanism for preserving aristocratic power, cloaked in sacred tradition. Justice, like land and office, belonged first to those who already held it. Power concealed in ritual cannot remain unchallenged forever. Mommsen identifies the codification of Roman law in the 12 Tables as a revolutionary moment, not because the content of the law changed, but because its form became visible. What had been sacred knowledge, guarded by the patricians and performed in exclusive circles, was now chiseled into public display, law as inscription, not incantation. The context was conflict. The plebeians, frustrated by decades of legal uncertainty and patrician manipulation, demanded clarity. In 451 BCE, a board of 10 men, the Decemviri Legibus Scribundis, was appointed to write Rome's first public legal code. A year later, a second board completed the work. The result was a unified body of law, carved onto 12 bronze tablets and posted in the forum for all citizens to see. This, Mommsen argues, was not democratization in the modern sense. The patricians remained dominant. The magistracies were still theirs. But a threshold had been crossed. The rules of the game were now legible to those who were expected to play it. The laws themselves were harsh, often primitive. They included capital punishment for theft, allowance for creditor slavery, and brutal provisions for family authority. There was no idealism in their phrasing, only the force of custom distilled into fixed expression. Yet what mattered most was that they were public. The plebeians could now contest decisions with reference to law, not hearsay. Legal process ceased to be magic. It became argument. Mommsen notes that the 12 Tables had a symbolic resonance far beyond their content. They were treated as sacred in their own right, memorized by school children, invoked by litigants, preserved even as later reforms rendered them obsolete. They were Rome's first assertion that justice must begin with form, and form must begin with transparency. No longer would law reside in the mouths of priests. It would live, quite literally, in the public square. The Roman courtroom was not a space for persuasion. It was a stage for precision. Mommsen emphasizes that Roman legal procedure was not about the spirit of the law, but about strict adherence to its form. Justice was not administered by professional judges or legal scholars, but by magistrates, citizens elected to office, and by laymen acting as jurors or arbiters. Authority came not from expertise, but from institutional role. Legal action in early Rome followed a formal script. The legus actio system required exact verbal formulas. A single misplaced word, a delayed appearance, a failure to cite the correct calendar day, Any of these could render a claim invalid. The law was not interpreted in spirit, it was performed by rule. In this environment, legal disputes were less a contest of arguments than a test of procedural mastery. Knowing the law meant knowing the sequence. It meant knowing when and how to act, not just what was right, but what was required. A plebeian could have justice on his side and still fail in court if he missed a word, a gesture, or a deadline. Mommsen is clear. This was not accidental. It was a feature, not a flaw. The formality of Roman procedure protected the state from disorder by limiting interpretation. It placed a high premium on civic discipline, legal literacy, and procedural correctness. But it also narrowed access. Only those trained in the formulas, mostly patricians and their clients, could navigate the system effectively. Even as Rome evolved, and new forms of procedure replaced the legious actions, the Roman preference for rigid structure endured. Trials in the Republic continued to follow detailed protocols. Appeals went through defined channels. No matter how obvious the injustice, a misstep in form could nullify a claim. To modern sensibilities, this may seem cruel. But Mommsen sees something else, a civic culture that feared arbitrariness more than error. The goal was not fairness in the abstract, but predictability in practice. The law could be harsh, but it would not be chaotic. In this system, legal authority belonged not to individuals, but to the form itself. The magistrate applied it. The citizens submitted to it. And the republic was held together by its repetition. Other ancient laws faded with their cities. Roman law outlived the empire that created it. Mommsen closes the chapter by turning from Roman legal practice to Roman legal legacy. What began as sacred formulas, as rigid ritual and patrician control, gradually evolved into one of the most enduring systems of jurisprudence the world has ever known. Rome's greatness did not rest solely on conquest. It rested on its capacity to encode order and to make that order portable, teachable, and enforceable across centuries and continents. The genius of Roman law was not innovation. It was accumulation. Rome did not seek to constantly rewrite its laws, but to refine them, to adapt precedent without discarding it. As new problems emerged, old rules were amended, clarified, or interpreted in light of evolving needs. But the structure remained firm. Legal authority rested in form, process, and civic memory. This approach created remarkable durability. Even as Rome expanded, even as its institutions changed, the legal core remained consistent. Contracts, property rights, inheritance, and public duties could be administered in Spain as in Syria, in Africa as in Gaul. Law became a unifying language of the empire, understood by magistrates, merchants, and citizens from every province. Mommsen sees this continuity as a defining feature of Roman statecraft. The empire could tolerate cultural plurality and regional difference because it imposed legal uniformity. It did not demand sameness, it demanded structure. And within that structure, order could be maintained. Long after the fall of Rome, its laws survived. They were studied, recopied, and reinterpreted in Byzantium. They resurfaced in the Middle Ages, taught in universities, forming the bedrock of civil law traditions across Europe and beyond. Nations that had never seen a Roman legion would one day govern themselves using ideas born in the Roman Forum. This, Mommsen argues, was Rome's truest conquest, not by sword, but by statute. Its law became its legacy. Its formulas, once whispered by priests, were now read by jurists in courts and classrooms across the Western world. Rome, through its law, had mastered not just its citizens, but the future. We'd love to hear your thoughts on possible future topics. What areas of human evolution would you like to explore next? Leave your suggestions in the comments, and let's keep the conversation going. As always, our references and further reading are listed in the description below if you'd like to dive deeper into the subject. Thanks for watching, and we'll see you in the next episode.